Good day. My report is about legal theory, public policy, and legal evolution. I will report the first part of the topic, and the other half will be reported by my colleagues. Legal ideals and juridical lawmaking. It is still a common practice among lawyers to look upon legal ideology as a useless speculation of theorists, irrelevant to the administration of law. Many of the contemplus uterans practical lawyers on legal theory as metaphysical speculation is none perhaps is more sweeping than the dictum of Lord Sommer, then Hamilton L.J. in Bilix versus Bishop of London. The vague jurisprudence which Lord Sommer had in mind was Lord Mansfield's conception of equity and natural justice as foundation of a principle of unjust enrichment. Lord Sommer's own attitude was, however, itself the profession of a particular juristic faith. Only a few decades later, the vague jurisprudence which Lord Sommer condemned has found increasing recognition by English courts, which have gone a considerable way towards acceptance of a principle of unjust enrichment based on general equitable principles. Legal positivists could delude themselves that they were not concerned with legal ideology. In reality, these lawyers were legal philosophers, like everyone who has to solve legal problems, but their philosophy was often inarticulate. Such self-delusion makes it psychologically easier to mold the law in accordance with beliefs and prejudices without feeling the weight of responsibility that burdens lawyers with greater consciousness of the issues at stake. The contrast may be illustrated by two judicial pronouncements. Lord Finlay observed in the case of Crown Milling Company versus the King, it is not trivial to adjudicate between conflicting theories of political economy. Armed with this pronouncement, the learned lord proceeded to give a judgment regarding the validity of the New Zealand Marketing Statute, which upheld principles of extreme economic liberalism against state supervision. Practically, all English decisions which are concerned with matters of economic competition, example, in conspiracy or in restraint of trade, display a similar outlook. Economic doctrines of far-reaching consequence, such as principles according to which price or market, control or monopoly of production may be upheld, have even developed in a rather haphazard action manner, without much consciousness of the economic and social problems at stake, and with little, if any, scientific inquiry into such economic problem as that of a fair, reasonable price. The contrast strongly with the following judicial pronouncement of Holmes. The former of these judicial utterances expresses the opinion that the lawyers solve legal issues which involve economic and social problems by a process of purely legal reasoning. The latter utterance reveals a deep appreciation of the independence between judicial and social economic ideology. Holmes J. himself chooses a solution characteristic of a judge in a non-totalitarian country, who is aware of his social responsibility, conscious of the political problem before him in the form of legal dispute, but convinced of his duty of impartiality in the balancing of social forces, and equally convinced of the duty of the judge to live the shaping of the political principles of society, essentially to the proper legislative authority. A more precise analysis is, however, necessary and possible of the ways in which practical lawyer may come into contact with legal theory. The practical lawyer comprises everyone concerned with the administration of law. Although the judge figures prominently, the legal advisor, whether in industry or before the court, and the administrator are practical lawyers in this sense. If it was ever possible to maintain a clear-cut distinction between law and administration, such distinction has become more and more relative as the modern delegation of lawmaking as well as judicial and quasi-judicial powers to administrative organs mingles legislative administration and judicial functions. The Blacktonian doctrine of the declaratory function of the courts, holding that the duty of the court is not to pronounce a new law but to maintain and expound the old one, has long been little more than a ghost. From Halls and Jay to Pound and Cardozo, contemporary jurists have increasingly recognized and articulated the lawmaking functions of the courts. The radical transformations, which for example, contracts, torts, or family law have undergone at the hands of the courts, have made it increasingly difficult to maintain the time-honored fiction of the declaratory role of the judge. It is not perhaps surprising that it should have been abandoned more wholeheartedly in the United States than in England. The profound effects in all walks of life of the interpretations of the Constitution by the Supreme Court, a Constitution which has in theory remained almost unchanged and yet governed the legal life of the country for almost 2 centuries, have long created in the United States picture of the judge and his function very different from the traditionally cherished England. The celebrated dictum that the Constitution is what the courts say it is has, if anything, been reinforced by the momentous decisions rendered by the court during the last decade in such matters as school segregation, voting rights, and the redrawing of election districts. In England, it may be that sheer respect for tradition, or perhaps a lingering love for the role of fiction as a major agent in legal evolution, are responsible for the survival of an increasingly untenable doctrine which was, moreover, never adopted by some of the greatest British judges from Holt, Mansfield, and Blackburn to Wright and Atkin. In the same Pound stressed that legislation, common law, administrative, and judicial justice demanded different types of social engineering. He considered certain subjects such as property and commercial law as a more susceptible of legislative formulation than of power, example, the law of torts or fiduciary duties. 2 factors are particularly relevant to Pound's statement. One is the dependence of scope and extent of legal idealism on the political structure of the system which it operates. The other factor is the unprecedented advance of social service legislation in the common law systems, especially in England, and the consequent intermingling of political law and lawyers' law. Both these factors call for a critical examination of Pound's thesis. The judicial role in 3 types of legal systems. 3 types of legal systems must be distinguished for the purpose of this analysis. The first is totalitarian society. As shown in previous chapters, it is characterized by close sub- subservience of the judicial machinery to the dominant political ideology. This operates more strongly in some fields of law than in others. Both the Nazi and the Soviet regimes retained many traditional concepts of civil law, but ensured its subvergence to political ideology by the selection of the judiciary and by destruction of effective guarantees of independence. In Nazi Germany, the book of civil and commercial law remained intact, but in all cases of ideological importance, the courts distorted the existing statutes for new political purposes wherever necessary. In the field of public and criminal law, the intrusion of political ideology is more direct and absolute. While Nazi Germany preserved the bulk of the existing system of law, other than constitutional law, twisting in the new purposes and sidestepping it whenever necessary. Soviet Russia introduced a new code of civil law. Both yielded to the necessity of establishing a sphere of relatively secure rights even in a society of political absolution. This explains the attempts of both German and Soviet courts to re-establish the certainty of legal concepts and institutions against sheer utility and arbitrariness. It explains, for example, the attempt of the Soviet Supreme Court to restore the conception of individual guilt in criminal law, and the parallel refusal of the German Supreme Court to convict outstanding enemies of the Nazi regime in all cases. But either case, ordinary justice is subject to being overruled by administrative action. Although it seems that recent Soviet law reforms somewhat reduce the scope administrative inherence. In this type of society, the judge is indeed rather free from the rule of statutes and codes and from all written texts. He is enslaved instead to the political dictates of his superiors, and the sanction for non-compliance is severe. When under the law of 1935, a German court convicted an accused because his act was contrary to the healthy instincts of the people, he acted as a direct mouthpiece of the political executive. In totalitarian systems, this is underlined by the power not only of the superior courts but the Ministry of the Commissariat for Justice to give instructions of people on the decision of cases. The second and third type are non-totalitarian systems. But with regard to the scope and character of judicial lawmaking, a basic distinction must be made between federal systems, in which a court is the ultimate interpreter of the Constitution, and other systems in which the parliamentary lawgiver is not subject to judicial control. Within the common law world, the former type is represented by United States, Australia, and Canada, the latter by Britain. Some account of the extent to which higher law ideas influence the judicial interpretation of a constitution has been given earlier. But the problem goes deeper and further than the infusion of the natural law ideologies into the interpretation of the Constitution. The extension of planning in social services activities and the particular change in the scope and structure of commerce has exposed constitutions and courts to a particular strain in recent years. This may be illustrated by some recent developments in the interpretations of the American, Australian, and Canadian institutions. Under Article 1, Section 8 of the United States Congress, has power to lay and collect taxes, duties, impose, and exercise to pay the debts and provide for the common defense and general welfare of the United States. But all these duties, imposed, and excises shall be uniform throughout the United States. Four of the majority judges took an intermediate line by saying that the state's certainty could not claim immunity even according to the now outmoded view of the court on the limits of proper government activity. But they admitted the possibility that federal taxation might be such a character as to depict states' performance of its sovereign functions, even if it did not discriminate between state and private enterprise. A later decision of the Supreme Court gives an almost classical example of the conflict of judicial approaches of the problem, constitutional interpretation, which involves an appreciation of social and economic policies. Black J., with whom Murphy J. concurred, expounded the philosophy of the social welfare state. He regarded the majority view as an improper judicial interference with the legitimate regulating functions of government, and as revival of recreationary philosophies. He thought that the facts before the court were insufficient to decide whether the action of the commissioner had been one on the side of the line or the order. The three opinions in this case express at either extremely starkly conflicting philosophies of state, power, and individual economic freedom, as reflected in the American Constitution, and between the extremes, a pragmatic approach in which the conflicting interprets policies and purposes regulatory action are carefully weighted. Such conflicts are inevitable where independent judges have to interpret static laws in a dynamic society. Indeed, such tensions are the lifeblood of democracy. Subservience in the dictates of government would be the price at which anonymity could be bought. For it is not only the conflict of values and philosophies in a free society which produces such clashes, but also the frequent divergence in the application of general principles to concrete issues, where the power of government is divided between federation and its member states, advocacy and planning of leisure, failure alone cannot decide the issue, where the further constitutional question arises whether in a federation there is an inviolable minimum of state powers which a federation cannot infringe by an expansive interpretation of taxing power, interstate commerce, and other powers to which modern social conditions give a meaning vastly different from the time of the founding fathers. The expansion of the federal legislative scope of power in the area of economic and social welfare has been achieved despite two basic arguments with which the Supreme Court has been faced. The arguments for restricting federal powers based on theories of individual rights and resting mainly on economic substantive due process have been discussed above in the previous chapter. Other arguments have been based on restrictive interpretations of the Commerce Clause, as well as other Article 1 powers. Recent legislation by Congress in the area of racial discrimination has rekindled the issue of the permissible scope of federal power based on the Commerce Clause and other Article 1 powers. The highly controversial public accommodation sanctions of the 1964 Civil Rights Act are specifically based on powers derived from the Commerce Clause. This has been sustained by the Supreme Court in two decisions. The fact that Congress was also dealing with what is considered a moral problem does not detract from the overwhelming evidence of the destructive effect of the racial discrimination has had a commercial intercourse. The High Court alternatively interprets the Australian Constitution is not hampered by enactment of inalienable individual rights and the Due Process Clause of the American Constitution, but an ambiguously drawn provision of the Constitution has involved it in equally deep political and social issues. Section 92 provides that on the imposition of uniform duties and customs trade and intercourse amongst the stages whether by means of internal carriage or ocean navigation, shall be absolutely free. Among the powers reserved to the provinces in the class of subject, property and civil rights in the province, the history of sections 91 and 92 and the opinions of most jurists and historians confirm that the general power of the Dominion was deliberately devised as a paramount power for the strengthening of the new federal authority. Not only did Section 91 give the Dominion all residuary power, but also cut down specific powers of the provisions through the enumeration of 29 classes of subjects as illustrations of the scope of the federal general power. Two further classes were added to the enumeration of federal powers by amendments. In practice, the relationship between Dominion and provincial powers has been largely reversed ever since the Privy Council in the local prohibition case. The Privy Council, following the Supreme Court Canada, also held that the phrase property and civil rights must be understood in the largest sense. Among the many dramatic consequences of this approach have been the invalidation of the so-called Canadian New Deal legislation, a series of statutes relating to minimum wages, limitation of hours of work, national unemployment and social insurance, and marketing regulations for natural products. All these statutes were thrown out on the ground that they were interferences with the exclusive power of the provinces and legislate in relation to property. In effect, judicial interpretation has thus assimilated the Canadian Constitution. Judicial role in the British system. The problem of judicial idealism is different and simpler, where the check on the action of the government is not controlled by abstract law, but by popular organ of government. In this type of society, classically exemplified by the British constitutional system, the judge is spared much of the dilemma which constantly confronts judicial guardian of a written constitution. He is not compelled to adjudicate on legislative policy. He cannot question the validity of a statute. In the English legal system, judicial creativeness flows through narrower channels. Thus, restrictive actions of various kinds, but mainly prerogative orders, enable the courts to restrain administrative arbitrariness. The actions of local authorities and other statutory bodies may be declared invalid if they are held to be unreasonable or an abuse of powers. The actions of ministers may be held invalid where the minister acts in a quasi-judicial capacity and offends certain principles of elementary justice. On the whole, the limited scope of these checks and the steadiness of long-settled constitutional tradition have preserved the British judiciary from the ideological warfare into which the American Supreme Court has at times been drawn. It has therefore given them a truer judicial independence, rather than the theoretically more perfect system of checks and balances. Interpretations of statutes and precedent. The major function of the judiciary lies in the interpretation of statutes and the application of common law precedents. In this field, the problems are substantially the same for all common law jurisdictions. As a subsequent chapter will show, they are indeed not basically different in civil law jurisdictions. The English, as much as the American, Canadian, and Australian judge, whether he interprets a statute or applies a common law precedent, is faced with the perennial problems: how to balance the need for stability and certainty embodied in the principle of stare decisis with the need for the constructive adaptation of the law to changing social needs, how to balance the certainty aim. Principles of statutory interpretation. The English lawyer does not interpret general principles embodied in a written constitution, nor does he, apart from a few minor exceptions, interpret codes which, along with the comprehensive settlement of the law, instruct him as the principles of interpretation. He does administer and interpret an increasing number of statutes, but psychologically, if not statistically, there still appear as exceptions rather than as rule. And the theory of statutory interpretation is accordingly rather undetermined. For a consistent and constructive theory of statutory interpretation, one would have to go back to Tudor times. The four rules of Haydon's case give a clear basis for a broad and progressive interpretations which excludes neither parliamentary history nor the consideration of legislative policy. The equity of a statute, as expounded by Plowden, is in his note on Aston versus Stad, contains a striking anticipation of modern principles of judicial equity. This is an almost verbal anticipation of the language used in the Swiss Civil Code of 1907. The principles of Tudor period, a time of strong government and active lawmaking, have however given way to a much narrow judicial and professional legal attitude towards the interpretation of statutes. It is not within the scope of this chapter to discuss the historical development in detail. By the beginning of the 20th century, the rules of Haydon's case had been substantially restricted by the development of the doctrine, which excluded travaux preparatoires from judicial consideration and thus went from to prevent the judge from studying the disease which Parliament had set out to cure. Rules and decisions. Any lawyer who expects from any set of rules an infallible guidance to the solution of the problems which life and law present in an unending variety and complexity can only deduce from the foregoing analysis that many rules cancel each other out, that the result is a vacuum. Such a conclusion, however, would be due to misapprehension of the judicial function in a free society. The great judges of all countries, and most articulately perhaps the great American judges of the present century, have not discarded technical rules, but they have been clearly aware of their limitations. They have looked at the issue and the statute before them, and they have balanced verbal and grammatical text against legislative history and social purposes in varying mixtures. Yet no general theory could or should be a substitute for the discriminating wisdom applied to the solution of a particular problem. The acceptance of theoretical rules, literal or sociological, golden or plain, other than as technical aid can only lead to judicial deception or to mental slavery. It is the privilege and duty of judges and other exercising judicial functions in modern democratic societies to decide a situation unhampered either by the political dictation of a totalitarian government or the construction of technical rules. Yet these rules cannot be entirely discarded, for without them we return to the chaos of free and kingly justice. Like Ulysses, the judge in interpreting statutes must steer between Scylla and Charybdis. The search for power, proper rules of statutory interpretation is part of the search for justice, which is unending. Precedent and legal development. That English lawyers have molded the common law by the infusion of legal ideas No one can doubt who compares, for example, the modern law of restraint of trade or the employer's responsibility or of charitable trust with that of some centuries ago. The evolution of legal ideas has been so overwhelmingly unconscious and inarticulate that perhaps the most radical rejection of judicial lawmaking by a contemporary British judge is the speech made by the late Lord Jowett, Lord Chancellor from 1945 to 1951 at the Australian Law Convention of 1951. It is quite possible that the law has produced a result which does not accord with the requirements of today. If so, put it right by legislation, but do not expect every lawyer, in addition to all his other problems, to act as Lord Mansfield did and decide what the law ought to be. He is far better employed if he puts himself to the much simpler task of deciding what the law is. Please do not get yourself into the frame of mind of entrusting to the judges the working out of a whole new set of principles, which does accord with the requirements of modern conditions. Leave that to the legislature, and leave us to confine ourselves to trying to find out what the law is. The distinction of precedent, on the other hand, is a favorite judicial device of developing the law, though it has the grave disadvantages of uncertainty and haphazardness. It takes three main forms. 1. The distinction of facts. 2. The relegation of objectionable judicial opinions to the position of obiter dicta. And 3rd, the reliance of one or more other judgment where the authority of a precedent rests on a concurrence of judgments which arrive in the same result for different reasons. Among immeasurable examples, the somewhat strained distinction established by the Lord Atkin in his judgment in Donegall versus Stevenson between a considerable string of former decisions and the case before the court may be mentioned. It illustrates the numerous possibilities that exist for distinction by speculating on omissions or ambiguities in a report, relying on one ground of a decision rather than another, referring to subsequent conflicting interpretations of a particular judgment, establishing minute differences of fact, or discounting reasonings which appear to be based on the erroneous interpretation of previous cases. It is no disparagement on the great speeches of the majority in the Snail case to say that the precedents discussed would easily have borne an opposite interpretation, as they did indeed in Lord Buckmaster's dissenting opinion and the considerations. Precedent in the criminal law. In 1950, the full Court of Criminal Appeal overruled an earlier decision of its own of 1939 on a question of bigamy and laid down its own principles in regard to stare decisis. The reasoning as formulated by Lord Goddard, C.J., for the court is remarkable in its implications. This court has to deal with questions involving the liberty of the subject, and with it finds on reconsideration that in the opinion of a full court assembled for that purpose, the law has been earlier misapplied or misunderstood in a decision which it has previously given, and that on the strength of that decision, an accused person has been sentenced and imprisoned. It is the burden duty of the court to reconsider the earlier decision with a view seeing whether that person has been properly convicted. The exceptions which apply in civil cases ought not to be only once applied in such case as the present. The direct part of this statement, the most open attack on stare decisis, yet made by a modern English court. Of course, limited to criminal cases, but the reasoning has wider implications. Some of the most important decisions involving the liberties of the subject, such as Lever Siege v. Anderson, have been civil decisions. Can it be seriously contended that expulsion from a trade union or professional disqualification are less fundamental importance to the individual concerned than conviction for a minor offense? Or is a distinction between major and minor criminal offenses implicit in the reasoning of the Court of Criminal Appeal? Whatever direct consequences of the decision, its motivation is a powerful attack upon the whole rationale of the doctrine of stare decisis. It openly admits that vital considerations of justice may be more important than past authorities. The common law jurisdictions of the British Commonwealth have on the whole adopted the English doctrine of precedent, but they have made considerable modifications. The Canadian Supreme Court has, after the abolition of appeals to the Privy Council, reaffirmed the strict principle of stare decisis, which it had laid down for itself in 1909. Although the court has reserved for itself a liberty to reinterpret its own decisions as well as those of the Privy Council, it has not so far made use of its reservation. On the other hand, a number of provincial courts of appeal in Canada have shown considerably more independence towards strict stare decisis and have departed from decisions of the English Court of Appeal, as well as from their own decisions in a number of cases. The Australian High Court has for many years past adopted a modified doctrine of stare decisis. It has recently reaffirmed its liberty to reverse earlier decisions where they are manifestly wrong, but at the same time, the majority of the court asserted that it would not reverse recent and well-considered decisions upon a highly disputable question. It is thus easier to point out the extent to which the courts can and do mold the law than to indicate a clear and consistent trend. There are certain broad limits which minimum standards of orthodoxy set to judicial reform of the law. Within these wide limits of possibilities of judicial lawmaking are great, but the way in which they are used depends on a multitude of fluctuating factors, such as the pressure of social or political events, on personal background and constitutional framework, on the relations between legislator and judiciary. This ends my report on the first part of the public policy and legal evolution. The next part will be reported by my colleague, Mr. Frederick Guzman. Good day.